In this video, we continue with Wills and Trusts, Chapter 4, Capacity and Contests. Let's begin with a discussion of undue influence. Undue influence is influence that is exerted over the testator in a way that overcomes their free will and causes them to make a disposition they wouldn't have made otherwise. Undue influence is commonly seen in fact scenarios where a caretaker isolates the testator from their friends and family and suggests to the testator that they should transfer their property to the caretaker. In re Estate of Duress is precisely one of these cases. Spinelli had moved in with his grandparents, Alice and Peter Duress, after Spinelli had a divorce. He helped take them to medical appointments, but didn't really do much else to help with expenses or the upkeep of the house. In 2007, Spinelli prepared a durable power of attorney, and he had his grandmother sign it. By 2008, Spinelli had taken over control over both Alice and Peter's checking accounts. Now, this was all done in secret without the remainder of the family knowing about it. Spinelli then hired a lawyer to draft a will for Alice. And that lawyer followed mainly Spinelli's instructions. The lawyer had talked to Alice, but she wasn't the one who directed the lawyer. The lawyer was not there for the execution of the will. The will was executed outside of the lawyer's office. That will left all of Alice's property to Peter. Peter was her husband. But if her husband Peter didn't survive her, a large portion of the estate will go to Spinelli. Now, Spinelli used the power of attorney he had to orchestrate a series of transactions that actually left him in even greater control of the assets. And it really divested some of his family members of assets that they would have gotten otherwise. He recharacterized them, essentially. So meanwhile, during this time, the grandfather, Peter, was suffering from Alzheimer's and had to be placed in a nursing home. A few months later, he passed away. To the extent that Spinelli used undue influence to procure the power of attorney over here, and to make the transfers over here, the court could use what was called a constructive trust to provide restitution for the family members. Now, the court paid particular attention to the burden of proof in this case because Spinelli was a fiduciary because of the power of attorney. And where there's a fiduciary that benefits from a transaction for which that person bears this fiduciary duty, then it is the fiduciary that has the burden of establishing that that transaction did not violate his obligations. So the linchpin in this case is that there was a confidential relationship between Spinelli and Alice. So there was this confidential relationship plus suspicious circumstances. And what were some of these suspicious circumstances? Well, the court said that there was an aura of secrecy surrounding the estate planning, as no one in the family other than Spinelli was aware that Alice had executed a will before her death. Now, much of the evidence that was presented in this case was circumstantial evidence. But the absence of direct evidence is pretty typical. And because the burden was on Spinelli, and there was a presumption that there was undue influence, Spinelli could not meet that burden. All right, let's turn to another case on undue influence, and yet another case full of gender bias. And that case is In Re Will of Moses. Fanny Moses, aged 57, died, leaving substantially all of her assets to her lover, Clarence Holland. Clarence Holland was a lawyer, and he was 15 years younger than she. Now, Moses had hired an independent attorney to draft the will. It wasn't Clarence Holland that drafted the will. But the court was not convinced. The court questioned why the lawyer she hired didn't prod her, didn't ask her more questions about why she would prefer to leave her estate to her lover over her family. So the court ruled for the contestants, for the family members. I'm not going to talk too much about this case because I feel like the language of the case speaks for itself. Lipper v. Weslow, our next case, is another case involving undue influence. This case also involves an attorney. The attorney's name in this case is Frank, and Frank wrote a will for his mother. His mother's name is Sophie. In that will, Frank allotted himself what would be more than he would get in intestacy. Most states would consider this a violation of professional rules of responsibility, especially because Frank did not send his mother to an independent lawyer to review the will. The will didn't leave anything to Sophie's daughter-in-law or the daughter-in-law's children or grandkids, Sophie's grandkids. However, the court noted that there was evidence that Sophie didn't leave anything to the daughter-in-law because they were being, quote, ugly to her. Because Sophie was of sound mind, although her will was unnatural, there was evidence on record to support her decision. So in this case, no undue influence was found. Now I'd like you to compare this case to In Re Will of Moses. What do you think justifies the different outcomes of these two cases? Now I'd like to quickly talk about two additional concepts. So we've already talked about undue influence and how that can be used to contest a will. The second is duress. And the third is fraud. Now the court will make a finding of duress when a wrongdoer threatens to perform or does perform a wrongful act, and that act coerces the testator to make a disposition that they wouldn't have otherwise made. Now, the difference between duress and undue influence is that duress involves an actual act, like holding a gun up to someone's head, or the threat of an act, like threatening to kill someone. And that act convinces them to make a disposition that they wouldn't have otherwise made. Whereas undue influence is more subversive. Now, for fraud, on the other hand, for fraud to occur, the wrongdoer must have knowingly or recklessly made a false representation to the testator about a material fact that was intended to and did lead the testator to make a disposition that they wouldn't have otherwise made. Now, the difference between fraud and undue influence is that in the case of fraud, the testator retains their free agency and they freely make a new estate plan or a new disposition, but they do so as a result of them having been misled. In the case of undue influence, the testator makes a new estate plan because of the influence that overcomes the testator's free will. So the testator doesn't really have free will when we're discussing undue influence. Now, in practice, undue influence and fraud and even duress are often alleged together. And with that, we end chapter 4.